Welcome back to our YouTube channel. So this is where we talk about relevant issues relating to the law, how it affects you, how it affects your business, and all of that. So today we're going to be talking about the contents of a shareholders agreement. And I think in one of our discussions we've talked about shareholding, particularly for startups. When you establish a company, the company is made up of shareholders who form the owners of the company. Now they have different stake, different shareholding. Those who have the higher shareholding will control a higher stake in the company. They also have what we call the MEMAT, Memorandum and Articles of Association. Right now, that MEMAT, particularly the articles, is the constitution of the company. It guides the company. It tells you the kind of decisions that can be taken and the role of the directors and some of those other things. Generally, the constitution of a company, because every organization that wants to succeed must have a guide, a constitution, right? So that is it. Now, aside the articles of association, every shareholder is also advised. In fact, the company is also advised to have a shareholders agreement. That shareholders agreement guides and binds the shareholders, the owners, the members of the company. So we're going to be talking about the contents of the shareholders agreement. But quickly, before then, I will just tell you some of the advantages of the shareholders agreement. You have the confidentiality of terms. There are some things you wouldn't want to include in the articles of association because it's a public document. Anybody that wants to see the article of association of your company can request that from the CAC. So it's available for everybody, but there are some details you want to keep confidential. So you include that in the shareholders agreement, which is a private document. Then the shareholders agreement has less formality, right? So members can just come together, scribble down something, of course, with the correct content and sign it. Then for the shareholders agreement, one of the benefits is that you can choose your jurisdiction. Okay, so unlike the MEMAT, the articles, shareholders under shareholders agreement may freely choose the jurisdiction for arbitration or litigation of disputes arising from the agreement. But in the MEMAT, generally it's always Nigeria. Okay, and mind you, the shareholders, the owners of a company may come from different parts of the world. Okay, now, so we're going to look at the important clauses. If you're drafting a shareholders agreement, or if you own a company with other people and you want to have a shareholders agreement, what are the clauses that must be in that shareholders agreement? Number one, you must have the management of the company and the director's obligation. So a shareholder, like I told you, is a part owner of the company, and it is not necessary that the directors, the shareholders also become the directors. The shareholders may not have the time, so they give the directors the power to run the company on a day-to-day basis. So the shareholders agreement should contain the director's obligation. It specifies the nomination, appointment, removal, remuneration of directors, and those kind of things. Then it should also contain, this is another very important clause, the share sale and transfer clause, right? These clauses regulate the holding of shares and the prerequisites for transfer of shares. So most shareholders agreement basically would include preemptive rights. Preemptive rights refers to the fact that if as a shareholder you want to sell your share you must first of all offer the share to a fellow shareholder before you sell it out to someone from outside. All right, so that is a preemptive right. So the shareholders agreement should contain that, and that's because you want to keep the control within the circle of those who establish the company. And this is very common with private limited liability and with private companies. Okay, so the agreement may also stipulate criteria for issuance of shares, of new shares. It may also contain a restriction on transfer, or of course an option to purchase on death or other disability. Another clause that must be in a shareholders agreement is the minority protection. Shareholders don't hold shares in equal proportion, so there's those who hold minority of the shares. They also want to be protected. So the shareholders agreement must make provision for that. Then it should also make provision for payment of dividends. So these clauses would usually set the duration and regulations for payment of dividends and profit sharing percentages. The benefit of being a shareholder is that you get dividend. All right. The benefit of borrowing money to someone is that you get interest and your capital. The benefit of being a shareholder is that you get dividend, which is you sharing the profit of the company. So the shareholders agreement makes provisions for that. Another important clause is the capital and financial contributions clause. It includes clauses which set out what the initial contributions is to be by the shareholders and how future capital contributions or financing arrangements are made. Okay, the company may want to raise capital in the future. So how that is going to be done, those are things that should also be contained in the shareholders agreement. Then you also have to include allocation of key roles and responsibilities. So this sets out the respective roles of each shareholder. So everybody knows who does what, so you don't have confusion. Then the termination of the agreement. The shareholders agreement should contain a clause for termination. Now, when new shareholders come in, they don't need to draft a new shareholders agreement. There's what we call the accession agreement. So you just sign it and then you become bound by the shareholders agreement that has always been in existence. So these are things you should just take note of, okay, and make sure you prepare your shareholders agreement bespokely, but of course, putting these clauses into consideration. We hope this has been helpful to you. You can drop your questions, drop your comment, and if you like the video, you can also share. And please don't forget to click on the subscribe button. Thank you for your time.